I am. I am. Hello and welcome to the Institute for Security Studies. Today we attempt to answer the question as to whether the International Criminal Court needs to be reformed. For a lot of people, the story of the International Criminal Court is a story of a court that prosecutes Africans for crimes committed on the African continent. The story doesn't go much further back than that. But the story of the ICC, which myself, together with Phil Clark and Judge Richard Goldstone this afternoon will take you through, is a story that goes maybe, at least, over a century ago. In the course of this discussion, we are also launching a book that Phil wrote on distant justice and how, in many ways, the ICC's work impacts on African politics. Dr. Phil Clark is a scholar of comparative and international politics at the School for Oriental and African Studies in London. He co-directs the Center on Conflict, Rights and Justice, and in today's discussion, he will unpack some of what he wrote about in his book, but also all the things that have happened since, Phil. Joining us today is also Judge Richard Goldstone from the African Group on Justice and Accountability. Judge Goldstone, at least to a South African as well as an international audience, is a person that needs very little introduction. He's a judge who served as a South African judge at the High Court, Supreme Court, as well as the Constitutional Court of South Africa, and who, during the time of apartheid, gave some liberal judgments that in many ways undermined the state of apartheid. Apartheid, as many people will know now, is a crime against humanity and a crime that is criminalized in the Rome Statute of the International Criminal Court. Judge Goldstone was also the head of the Commission into Political Violence in the early 90s and the first chief prosecutor of the International Criminal Tribunals for the former Yugoslavia and Rwanda, as well as having been part of the UN fact-finding mission into Gaza. So in many ways, we've got two speakers today who know international criminal justice, whether through their study, through their practice, but also, and I think quite importantly, through their interest in these issues. Phil, of course, you don't come from a legal background. Instead, you come from a background that looks more at the politics, not just the politics of the International Criminal Court, but really the politics of justice. Your book is titled Distant Justice. And my first thought when I saw the title was less about distance in the geographical sense, but I thought about distance in terms of time. I thought about the fact that the International Criminal Court as a concept is something that was first thought about following the First World War, a century ago. It was a concept that started to maybe begin to take shape after the Second World War with the Nuremberg trials. But it was only a concept that finally, in the 1990s, despite the many struggles for liberation here on the African continent, as well as in Asia, despite the very various repressive systems, it was only a concept that came to life finally in 1998. So for me, it was a long time coming. But you talk about the International Criminal Court and its practice. If you can introduce us to your work, Phil, tell us more about why you say, one, that perhaps justice is not as close as it should be.
Thanks, Ottilia, and thank you to ISS for the very kind invitation to be here. What Ottilia's asked me to do, I guess, is just to outline some of the key arguments in my book, Distant Justice. Let me start by explaining why I think we should think about the ICC as a profoundly distant institution. And then I want to try to highlight some of the problems that that distance is producing, especially for African societies recovering from mass conflict. I talk about the ICC as a distant institution in several respects. The most obvious one is its geographical distance from the societies that it purports to be delivering justice for. Based in The Hague, but over the last 15 years, profoundly delivering justice for states on the African continent. But this is also a distant institution in terms of its personnel and the expertise within the court itself. One of the things that has struck me in the 11 years that it took me to research this book is inside the ICC itself, whether we're talking about the Office of the Prosecutor or the Defence or the Chambers or the Registry, there is a very heavy emphasis on non-African technical legal staff driving this institution and doing the bulk of its work, most of whom, by their own admission, have very little, if any, knowledge of the specific African context in which they are delivering justice. One important manifestation of this is the reality that both in the Office of the Prosecutor and in the Defence, there is not a single investigator who comes from any of the particular African states where investigations are underway. So foreigners investigating very complex crimes on the ground, often in societies that by their own admission they have no previous experience in. And in some respects, that is, I argue in the book, a step backwards from the International Criminal Tribunal for Rwanda, where Justice Goldstone was the first chief prosecutor, where over time there was a realization that in order to investigate genocide crimes inside Rwanda, you needed Rwandan investigators who spoke Kinyarwanda, who knew the local terrain, who had networks of informants, and could gather as a result a much higher quality of evidence than non-Rwandans could. In that respect, we've seen the ICC take a step backwards with an absolute insistence on outsiders doing this very complicated work on the ground. We've also seen the distancing of the ICC from the domestic terrain in terms of the very limited field time that those investigators and other ICC staff members spend in situ in African states. Until several months ago, the Office of the Prosecutor had a working protocol whereby their investigators were to spend no more than 10 days at a time on the ground conducting investigations. So foreigners with very little experience in these places also spending very little time doing their work in a domestic context. And underpinning all of this is a very particular philosophy that I think informs all of the work of the ICC, which is the idea that to deliver impartial and neutral justice, the court must fundamentally detach itself from the societies in question. The further away it is, in practical and philosophical terms, the more likely it is to be even-handed. And there's also an idea that the domestic terrain is messy and it is manipulative. So if the court were to have too much knowledge and to get too embroiled in the domestic context, it would lead to the court being manipulated and instrumentalized in all sorts of ways. And so that is why I think we see these various practical components of the ICC distancing itself. What I argue in the book is that this mode of distant justice produces all manner of problems, both for the ICC itself and for the African societies where it operates. In terms of the court on its own terms, distant justice leads to all sorts of problems for this institution. I think this distancing approach has led to some of the very poor investigative practices and the very low quality evidence that both the Office of the Prosecutor and the Defence have gathered over the last 14 or 15 years. Recently, if we look at the acquittals of Jean-Pierre Bemba and Laurent Gbagbo, two of the highest profile acquittals before the ICC to date, what damns the ICC is not so much the acquittals themselves, because of course a court can acquit or convict on the basis of the evidence that is brought forward. But what damns the institution is the poor quality of the evidence gathered especially by the Office of the Prosecutor. And this was a point made by the judges in both of those cases, with the Office of the Prosecutor relying heavily on second-hand information, media reports, local human rights reports, but without the kind of detailed first-hand evidence gathering that you would expect an institution of this kind to be gathering. There is also a problem for the ICC that stems from distant justice, in the sense that this is a court today that we must recognise is structurally incapable of addressing crimes committed by sitting members of government. This is an enormous climb down for this institution. One of the reasons that was given in 1998 for the need to create the ICC was that it would deal with the toughest cases around the world that domestic institutions would be unwilling or unable to address. And in particular, there was an emphasis on government crimes. The assumption was domestic courts will not be able to deal with or would not be willing to deal with cases of their own executives for political reasons, and so therefore we needed a permanent international court to do these cases. What we must conclude in 2019 is that as it currently stands, the ICC is structurally incapable of dealing with cases of sitting government officials. This is a court that is only for non-state actors. It's only for rebel leaders. It's only for recently deposed political elites. And there are numerous reasons why that's the case. The court is fundamentally reliant on state cooperation, but also what we have seen in various African states over the last 15 years is that the court internally does not possess the political knowledge that it needs to navigate state power on the ground. Insisting on distance, insisting on generalist technical staff, there is a lack of awareness inside the court of how you negotiate with and navigate African states, for example. And so as a result, we have either seen the Kenyan and the Sudanese governments targeted by the court completely steamroll the ICC's operations, blocking investigations, and leading to the Office of the Prosecutor having to drop the charges in those situations. Or we have seen the ICC, in more cases, develop very cozy relations with African states. Uganda, the DRC, Cote d'Ivoire, Mali. Cases where we have seen the Office of the Prosecutor in particular develop extremely tight cooperation with those states, leading to, I think, the kind of relationship that has ensured that that office has not investigated government actors. And in the Ugandan and Congo cases I argue in my book, this stemmed from the fact that the Office of the Prosecutor actively chased those situations and lobbied the Museveni and Kabila governments to refer those situations to the court. The Office of the Prosecutor always preferred to describe the Uganda and the DRC cases as examples of simply being invited in by African states. Well, my research shows something very different, which was that the office chased those cases and, in these lengthy negotiations leading up to the state referrals, had to convince the Kabila and Museveni governments that this would be in their interest. Ultimately, that they could protect themselves from legal scrutiny and use the ICC as a weapon against their military and their political opponents. Again, much of this transpired because of a profound misunderstanding or ignorance within the ICC as a whole about how state power in Africa in fact operates. And so without that knowledge of African context, the court has left itself open to being instrumentalized by the likes of the Ugandan and the Congolese governments. But finally, I think what is perhaps more problematic, stemming from the ICC's model of distant justice, is that it has produced a range of important problems for African societies themselves. One key problem for African states, stemming from the first set of problems that I've already talked about, is that inadvertently the ICC in fact has entrenched state power in places like Uganda and Congo, emboldening and in some cases almost enabling those states to continue committing violations in the full knowledge that they would never be subject to international legal scrutiny. And so we have seen large-scale violations committed both by the Ugandan and the Congolese governments against their own citizens in the same time that the ICC has been intervening in those states. What also comes out of my research over the last 11 years, especially at the community level in northern Uganda and in various parts of eastern Congo, is that the ICC now suffers from a complete legitimacy deficit amongst affected communities. And there are numerous reasons for that, but one of the key reasons that is consistently articulated in the hundreds of interviews that I've done in these parts of Africa over that period is that the court is not a legitimate actor because it has refused to go after state crimes. One of the very important messages coming from the local level in northern Uganda and eastern DRC is even in communities that have suffered massive rebel atrocities, many local people ascribe a particular gravity to government crimes. So I remember an elderly lady outside of Gulu town in Acholi sub-region of northern Uganda several years ago saying to me, the LRA has abducted 2 of my sons. I have witnessed firsthand murder, rape, and various other major crimes at the hands of the rebels. But the crimes that I consider gravest are those committed by the UPDF, by the Ugandan army. The reason being, people expect the rebels to commit massive violations. They don't expect their states to do so. And so government crimes break the social contract. There is something especially grave about state atrocities. And so therefore, in the eyes of many affected communities, there is something especially delegitimizing about the fact that the ICC has refused and in certain senses is unable to deal with government crimes. We've also seen distant justice in the way that the ICC has gone about it, undermine domestic judicial institutions in various African states, something that I dedicate a chapter to in the book. The distance idea that the ICC operates upon believes that the domestic terrain, including domestic institutions, are debased and incapable of dealing with serious cases on their own. And so it assumes the superiority of the ICC. What that has led to in various situations, ultimately, is the ICC stealing cases that could otherwise, and in some cases were already being, investigated by domestic courts. And one of the key examples that I give in the book relates to the Ituri court system in northeastern Congo, which was already dealing with the cases of Lubanga, Katanga, and Ngujolo when the ICC intervened. And so one of the problems here is that we see the ICC believing itself to be superior because it is more distant, taking cases that ultimately should have been dealt with by the domestic courts. And finally, because of distance, we see an ICC that is deliberately neglectful of the domestic context and the consequences of its work on the ground. And one of the ways that this has played out is the ICC, I think, being blind to the fact that it is limiting the options that African states have to find their own remedies to the crimes that they have experienced. This absolute insistence on the need for international criminal justice in all situations of atrocities that involve high-level perpetrators means that African societies now are struggling to find the scope for creativity and flexibility that they need to tailor remedies in a way that makes sense to their particular context. And we have seen this time and again over the last 10 to 15 years. We've seen it during messy peace negotiations in various African states. Part of the problem in peace negotiations around Africa today is that the idea has seeped into the minds, especially of international and domestic mediators, that you can no longer use an amnesty, even a heavily conditional amnesty, to deal with the atrocities of the past. Because if you were to do so, you will attract major international criticism. There must be international justice for international crimes, is the view. And perhaps the pithiest way to express this particular problem around lack of flexibility and lack of creativity, and it's an important point to make given where we're located today, is that it would be almost impossible for South Africa in today's context to decide to use a heavily conditional amnesty in the context of the Truth and Reconciliation Commission, as it did as part of the post-1994 transition, because to do so would attract enormous international criticism and enormous international pressure to prosecute the leaders of the apartheid regime and other violators of the past. And that is a major problem for states around the world trying to find their own solutions to deal especially with peace negotiations and the legacies of conflict. So we have a distant court, detached from domestic context, detached from domestic consequences, that I think not only is producing numerous problems for itself as an institution, but also in many ways doing profound damage to the African societies where it's been operating over the last 15 years. Thank you.
Thank you, Phil. What a way to start an event. You've spoken about the court as an institution being distant, but likewise also of its personnel. I'm going to sort of let you rest for a bit. So I'm going to turn to Judge Goldstone. As a person who headed the prosecution in the International Criminal Tribunal for the former Yugoslavia, yourself a South African, doing this work for the UN essentially, but also as a person who has through the various interventions and the work that you've done, has made your voice quite loud around atrocity crimes that are being committed elsewhere, not just in South Africa, but elsewhere in the world, most notably and perhaps quite recently in respect of Gaza. Having heard what Phil has said about the International Criminal Court, what are your thoughts? Is there space for prosecutors like yourself, judges like yourself, who aren't from the place where crimes are committed, but who have a particular legal or otherwise expertise on those issues? Yeah.
Well, the short answer is yes, but before I give reasons, let me thank the ISS for inviting me to participate in this discussion with Phil Clark. And let me also preface my remarks by congratulating Phil on an outstanding book. I must say I found it a wonderful read, and it is essential reading for anybody interested in international criminal justice. It's backed up by, as Phil has mentioned, not loudly enough, it's backed by 11 years of research on the ground. And that, I think, gives the book particular, and if not unique, interest to people who follow international criminal justice. Let me say too, and I know Phil will agree from the couple of hours we spent together this morning, that he's written this book and he's made strong criticisms of the ICC, in particular the Office of the Prosecutor, from a stance of somebody who supports the International Criminal Court.
Yeah, it might not sound like it, but that's true.
I mean, I thought I should say that because you may not have thought so from listening, but I think that's very important. So we both come from the same starting point. I have no doubt if there wasn't an International Criminal Court, we would be having meetings like this to say how do we set one up. So the question is making it more efficient than it is. Certainly not destroying it.
Yes.
So let me say too that, as has emerged from what Phil has said, the politics of international justice goes to the core of international criminal justice. When I taught courses on international criminal justice, I began and ended every class with reminding students that if they don't understand the politics of international justice, they don't begin to understand international political justice. The other point I would make is that one shouldn't generalize. I think one's got to look at each situation on its own merits. I was involved, as Attilia has mentioned, with the former Yugoslavia and Rwanda. Two such different situations, and they had to be handled. In some ways there were commonalities, but in many more ways there were differences. And I think if those involved in the Office of the Prosecutor don't have regard for the differences and for the idiosyncratic uniqueness of each situation, he or she is going to miss the boat. The other preliminary point I'd make, and the last one before I deal with some of the issues raised by Phil, is that the Office of the Prosecutor is not only a legal office, but is also a diplomatic office. I think any chief prosecutor of an international court, whether it was the ad hoc tribunals or Sierra Leone or the International Criminal Court, have to be able to negotiate with government leaders and at the same time keep a distance from them. And this is an appropriate distance. I'm sure Phil and I won't disagree about that. Any international prosecutor at the beginning of a new international criminal court is faced with a tremendous amount of pressure to get out indictments. That's the test. It's a political test. When I arrived in The Hague on August the 15th of 1994, I was told that if we want to get a budget from the UN, from the so-called ACABQ, the committee of the UN that has to approve budgets for every UN institution, they said if we didn't, this was the middle of August, if we didn't have an indictment out by the beginning of November, we wouldn't get a budget, because the budgeting people wouldn't accept that the court could work. If you don't get out an indictment, what's the point of a criminal court without indictments? So it was tremendous pressure And it was the reason that the first indictment that was issued in the second half of October of 1994 was against a man called Nikolic, who was indicted then of 12 murders, which in any national situation, if somebody in South Africa or in London were charged with 12 murders, it would be a cause célèbre, huge trial. In the context of the crimes committed in the former Yugoslavia or Rwanda or Uganda or anywhere else, 12 murders is what the press called small fish. But we had to get out an indictment. I would have preferred to have waited a year and issued the first indictment against Karadzic and Mladic, which we did within a year of my arriving in The Hague. But we couldn't afford to wait because we wouldn't have been allowed to operate without funding. So this is the political reality. And I think it must be seen, it must be taken into account in criticizing with hindsight the decision of the first chief prosecutor of the ICC, Luis Moreno Ocampo, deciding to get involved at the request of the Ugandan government in Uganda. It was an unfortunate decision, I believe, for many of the reasons that Phil has given. Firstly, it was politically hazardous. President Museveni would never have requested the ICC to get involved if it didn't suit him politically. It was obviously a political decision he took. And by the prosecutor agreeing, the prosecutor was playing into the domestic politics. And that wasn't a good idea. And of course, the courts of Uganda were open and running. So from a complementarity point of view, it was questionable as well. So I think it was a mistake, and also it gave rise to certainly an apparent bias in favour of the victims of the Lord Resistance Army and ignoring the victims of the Uganda Defence Force. Ocampo bravely said that he would be even-handed, but in fact he wasn't. There was never a real investigation into the serious crimes that were alleged against the official Uganda army. So I think these criticisms are, without any question, have merit, and should be lessons. They're important lessons to be learned from that. What I found fascinating in Phil's book was the way in which the officer, the prosecutor, sought the self-referrals from Uganda and the CAR. That wasn't the way they were presented. Until I read Phil's book, I was under the naive impression that the ICC was sought out by those governments. In fact, Phil's evidence is convincing that it worked the other way around, that the prosecutor sought those referrals rather than that. So let me stop there. There are many issues Phil has raised that I'm sure we'll be talking about, but let me leave it at that for the moment.
Thank you, Judge. You spoke first, and Phil, very few people who care about anything would not write a book about it, right? So if you didn't care for international criminal justice, you might have spent 11 years researching marine water life or something else. Not that there's anything wrong with that, but I think the dedication in putting together what I think is a brilliant book shows that you care for international justice. So you've said all you've said about what's wrong with the International Criminal Court. Bearing in mind that you care for international criminal justice, let's talk then about how do you, if you can, reform the International Criminal Court as one court. And I think this is a point that in both your interventions and Judge Goldstone, you spoke quite a bit around your experience working within the ICTY, for example, which I think is important, that when we have these conversations about the functioning or the dysfunction of particular institutions, that we also see them within the system or the ecosystem in which they exist. So, Phil, you've thrown all the things that are wrong. Tell us a little bit about how those wrongs can be righted, and perhaps, maybe, if there is anything, what is good at the moment about the way that the International Criminal Court has come into the playing field of international justice?
So I think Justice Goldstone was right to emphasise that I'm certainly not advocating for the complete collapse of the ICC. And I should have also said at the start I was very grateful to Justice Goldstone for reading the book in an extremely busy schedule in advance of this meeting. So I'm extremely humbled by that. In the conclusion to the book, I try to lay out a reform agenda for the ICC. I really do want this book to be a constructive contribution to these debates, because I do think that the ICC can play a very important role in addressing serious atrocities around the world. There are several elements, I think, to any reform agenda. The first one really is attitudinal or philosophical. I argue in the book that I think the ICC needs to go back to its first love. It needs to go back to the principle of complementarity, which frames the ICC profoundly as a backstop, as an exceptional institution. And distance in many ways is contradictory to complementarity, because distance frames the ICC as superior to domestic institutions, whereas complementarity says there should be deference to domestic bodies. The court should be a cautious intervener. And I think that's the starting point. I think we need to go back to the things that actually Ocampo said in his inaugural address as chief prosecutor, that success for the ICC would be an absence of cases, which turned out, of course, to be just a PR statement by him, because within a matter of months he was chasing the cases in Uganda and Congo. And it's rare, I think, that Ocampo gets some credit, but I'll give him credit for the fact that I think his reading of complementarity in those early days was absolutely spot on. And I think attitudinally the court needs to go back to that. What that means also is a fundamental reorientation of all of our discussions back towards domestic justice. And this is one of the things I advocate in the book. It's also something that I advocate in this pamphlet, which I'm hoping many of you have picked up, which is a kind of distillation of some of the arguments in the book, which is that I think we need to go back to thinking much more seriously about how we bolster domestic institutions. And I give lots of concrete examples, especially in Africa, of domestic courts and other domestic institutions that I think have developed a very important track record of dealing with atrocities. And so we need caution from the ICC, but we need much more time, attention and resource put back into a domestic reform agenda. Look, and domestic institutions are imperfect, so I'm not trying to romanticize them, but I think that we have begun to neglect that domain because of our insistence on the ICC. And then the final element of any reform agenda, I think, has to be a change of personnel in terms of the type of expertise inside the court. Ironically, in trying to be so distanced, in trying to eschew country-specific knowledge, the ICC has made itself more open to being manipulated on the ground. So the irony is it's tried to be apolitical, it's tried to separate itself, but because it doesn't fully understand the domestic terrain, African states are running rings around this court. What it actually needs to do is bring political expertise in-house. And that's not to say this needs to become a politicized institution, it just needs to be a politically savvy institution. And then one of the other things I recommend in the book is that the court needs to think very seriously about how it shrinks that geographical distance. Holding in situ hearings, having much more robust forms of outreach, bringing justice into the direct midst of communities affected by conflict. That would make an enormous difference on the ground, and it's the kinds of things that many communities that I'm interviewing in places like northern Uganda and eastern Congo are themselves calling for.
And a lot of the points that you've made don't actually need for a reframing of the Rome Statute of the International Criminal Court, nor necessarily of the institution itself. And I think that's important, because sometimes when we have conversations about reform, just the word itself makes people think, well, this is a mammoth task. I think we've already seen in small ways and in some significant ways the role that having an African chief prosecutor and an African head for justice and the complementarity division as well, how that has helped in the way in which the ICC engages on the continent. Now, over to you, Judge Goldstone. When you were working at the International Criminal Tribunal for the former Yugoslavia, the tribunal had primacy, right? So the tribunal was, for all intents and purposes, the first port of call when it came to international crimes. That's not to say other institutions could not deal with international crimes that were committed in the former Yugoslavia. We've seen a number of prosecutions in other jurisdictions. But it was to say that they were the first, and they were the ones that had the primary jurisdiction. The International Criminal Court is the reverse, at least on paper. Now, drawing on some of the lessons of having to work with domestic justice systems, and I'm calling here more on your experience now with the African Group on Justice and Accountability, right? In the various jurisdictions, and Phil has alluded to it, that there's so many lessons that can be learned from the domestic level about how to deal with mass atrocities, but also with other international crimes. Any experiences from your side that you can share on fixing complementarity, if I can put it that way, or rather centering complementarity as it should be within the way the International Criminal Court works?
Well, I think the first common requirements are transparency and consultation. I think that's essential. If any international court distances itself in that sense from the country which is being investigated, it's going to fail. And it was one of the first lessons I learned in both the former Yugoslavia and Rwanda. In both situations, the countries concerned were absolutely deadly opposed to the court. In the former Yugoslavia, Bosnia accepted the court because the victims were mainly Bosniaks. In the case of Rwanda rejected the court because there wasn't a death penalty, because there wasn't a separate prosecutor for Rwanda. I was appointed as chief prosecutor for both simultaneously, and that was a political decision taken by the Security Council. They didn't want differences to emerge between the prosecutor's office of a European tribunal and an African tribunal. And they objected, Rwanda also objected to the period within which crimes could be investigated to 1 calendar year of 1994. So, ironically, Rwanda was a non-permanent member of the Security Council when the Rwanda Tribunal was set up in November of 1994. And the voting on the Security Council were 13 in favour, 1 no, Rwanda, and 1 abstention, China. So Rwanda was foisted with the tribunal it didn't want. And what was important, and I don't say so from any personal point of view, but what was crucial in Rwanda was that the prosecutor was African. When I arrived in Rwanda at the end of November, after Rwanda voted no, I was literally physically embraced by President Bizimungu and then Deputy President Kagame as a fellow African who would understand what their problems were. I didn't get that sort of reception when I went to Belgrade, when I went to Zagreb. In fact, the very opposite. I remember my first meeting in Belgrade with the Minister of Justice, who said to me, "Why are you biased against the Serbs?" And I said, "Minister, I've only been in office about 3 weeks." I said, "Give me a few months to develop some prejudices." I said, "I don't know enough about you at the moment to have any biases. Give me time." which he didn't find amusing, let me say. But when I went to Zagreb, they were a little bit less undiplomatic about it, but they were equally against the tribunal. So we, and one of the errors made by the Yugoslavia tribunal was that we didn't have more outreach in the beginning. It didn't occur to us, frankly. It was the first ever truly international criminal court. We didn't think of local officers telling the local people what we were doing. That came. I was only there for 2.25 years after I left. The outreach programs began. They can never be sufficient. But the International Criminal Court did learn that lesson. It's tried outreach. How successful it's been, I don't know. Let me say one other thing from my experience. It's difficult to have people from the countries where you're investigating without being accused of bias. Let me give you an example. In the former Yugoslavia, Croatians, Serbs and Bosniaks speak the same language. They call it Serbo-Croatian. The same language. In Serbia they use the Cyrillic, the Russian lettering, but they speak to each other in the same language. And that was what I was informed when I arrived as somebody completely ignorant of the ground in the former Yugoslavia. And I decided that all our documents that we issued from the Office of the Prosecutor should be in the local language in addition to the two official languages, English and French. So I got our translation department to translate the first document. Within less than 24 hours, I had an irate Serbian charge d'affaires, Mr. Lopicic, saying, "How dare you issue documents in Croatian?" I said, what do you? He said, "I can see this document was translated by Croatian. We use different word orders, and there's some dialect differences which are really unimportant." And that forced me to decide we weren't going to issue documents. We couldn't afford to use five languages. We just didn't have those facilities. But it was the first time I found out that our chief interpreter was in fact Croatian. We had to get local people. And if we'd have had those people in our investigation section, it would have made the perceptions of the tribunal just about impossible. So it's difficult. In Rwanda, it's easier because you were dealing with a civil war situation. All the crimes were committed in Rwanda by Rwandese, Tutsi versus Hutu and so on, but they were all Rwandese, and they all spoke literally the same language, Kinyarwanda. So to employ people in Rwanda was a lot less hazardous than it would have been to employ local people in the former Yugoslavia. And that's why I say I think you must look at each situation separately and take into account distinct differences. I don't know sufficient, frankly, about the situations in Kenya, Central African Republic, and the other places that Phil has investigated. But I'm sure in some of them it could be done. It might be a bit more difficult in others. But it's an issue I don't think has been investigated. Should have been, but I don't think has been. So those are just some of the lessons.
And you bring about, I think, two very critical points, Judge. First, around the point of complexity of the cases, but before you get to the cases, the complexity of the situations themselves and the dynamics, socio-political dynamics within each particular space, right? And I think those are things that often, when we try to simplify, that we can lose sight of. The second thing that you spoke about related more to the issues around consultation and the importance of accurate information, but I think very importantly the issue of communication and clear communication. Now, before I turn to you, Phil, one of the interesting things that happened over the weekend, all interesting things happened over the weekend, was there was a recent interview that former President Thabo Mbeki gave. In that interview, it was given in April, which is the month in which we, in many ways, remember the atrocities in Rwanda. In the interview, he points out one, an acknowledgement, a re-acknowledgement of the crimes that were committed in Rwanda. He also alludes to the failure on the part of the then South African state to act better in respect of Rwanda. But then he makes one key revelation, which relates to a conversation he had with the late Pikota. And he says that one of the reasons, at least given then, was that in fact the South African state, in many ways, was supporting a rebellion or whatever in Rwanda, and therefore in many ways could be seen as being partly responsible by selling arms to people in Rwanda. What followed was a person who said, why can't the International Criminal Court prosecute the former President of the Republic of South Africa, F.W. de Klerk? To which I replied, the jurisdiction of the International Criminal Court is effective from 1 July 2002. This person said, but they prosecuted Charles Taylor. And I said, no, the Special Court for Sierra Leone did. But, and this was a part missing in the media clip that he sent to me, because the Special Court for Sierra Leone had to especially sit for Charles Taylor's trial outside of Freetown like it did for the other trials and in The Hague, he assumed that the only court in The Hague is the International Criminal Court, not the Special Tribunal for Lebanon where the trial was essentially held, not the ICTY or now the mechanism, not the International Court of Justice. And I thought to myself, if in 2019 people who are interested in international criminal justice and in holding leaders accountable for crimes committed don't know that the temporal jurisdiction of the International Criminal Court is from 1 July 2002, whose fault is that? That we conflate these institutions and that there isn't sufficient information. Phil?
I mean, I think a lot of this does have to fall at the feet of the ICC itself. I mean, I think it's true, as Justice Goldstone said, that the ICC had tried to learn many lessons regarding outreach from its predecessor institutions, but in fact, the ICC's outreach was still extremely shoddy from the outset. Not just internationally, but particularly in the African states where it was investigating. I mean, I'll give you one example, which was when I first started researching the book in northern Uganda. It was very soon after the Office of the Prosecutor had opened investigations in northern Uganda. And for the first 9 months, there was no outreach at all. So local people knew that there are ICC investigators here, but there was no information about exactly what they were doing and how their evidence was going to be used. When outreach eventually did begin, it took the form of an English language pamphlet in the New Vision newspaper. There are numerous problems with that. One is it's the state newspaper, so immediately in the minds of local readers, the ICC is in cahoots with Museveni's government. It's in English, the English language, which is not spoken by the vast majority of people in northern Uganda, and it's written for communities that in many cases do not have very high levels of literacy. And so immediately this showed that the court had a tin ear. The registry was very unclear about how to explain itself. And so I think this issue of communication is absolutely imperative because it is a sign of respect. It is a sign of respect for the court to say, we are going to, not just internationally, but on the ground amongst affected communities, explain ourselves. But in fact, this is something that I think the ICC still hasn't learned. Not only explain itself, but be responsive to people's concerns and questions. Because still, if you go to ICC outreach events today in Uganda, in CAR, in DRC, in Cote d'Ivoire, the tendency is for the ICC personnel to put up a PowerPoint with the ICC website on it, and then to give these incredibly didactic presentations explaining how the website works. And I've been to so many of these outreach meetings. Then people in the audience will have their hands in the air with a fusillade of questions. And the poor person at the front says, actually, you're going to have to direct those questions to my superiors in The Hague. So people's concerns are not being listened to. And I think these are some of the fundamental things that the court can do if it wants to start to communicate effectively. And this is not charity to local communities. This is what they deserve. And it ultimately helps the court because it will allow it to demystify itself in the minds of the people that it's working amongst. And one of the reasons that the ICC, especially the Office of the Prosecutor, has consistently found it difficult to find witnesses in northern Uganda and eastern Congo that are willing to cooperate with it is because of problems with outreach. So the registry has also produced problems for the Office of the Prosecutor. People say, we're suspicious of this court. We still don't really know what it is and how our evidence is going to be used. I don't want to give my testimony to these actors. So outreach is also an act of self-preservation on the part of the court.
We've spoken, in speaking about the International Criminal Court so far, we've spoken a lot and perhaps too much about the Office of the Prosecutor. So as we go into, I suppose, wrapping up this part of the discussion, I think it's important also, again, to recognize the various offices and agencies within the court, right? Whether it's the Office for Public Counsel for Victims and Witnesses, or, and you've pointed out already, the registry, or the various chambers. The appeals chamber today handed out its decision on Jordan, for example, a decision in which it finds that it didn't comply with the Rome Statute in not arresting Sudanese president, then, now former, President of Sudan al-Bashir, but then in saying that, referring to the UN Security Council, another organ that interplays with the ICC but isn't the International Criminal Court, and the Assembly of States Parties, which is the parliament, if I can call it that, of the International Criminal Court, that ought to not have been the case. So various departments within the court. When we speak about the International Criminal Court reform agenda, as you call it, is this reform across all those entities within the court? So first within the court, and then second, outside of the court, the UN Security Council, the Assembly of States Parties, can those be reformed? Yes, Judge.
Well, actually, you've raised some crucially important questions. Firstly, the organs of the court. Outreach is not strictly for the prosecutor's office. The prosecutor's partisan. I mean, I always had difficulties. My good friend David Crane, who was the first chief prosecutor of the Sierra Leone Tribunal, used to go around Sierra Leone having town hall meetings and telling people, I am your prosecutor. Well, I don't think that was, frankly, was all that appropriate, because there were some people on the other side who saw him being, therefore, a partisan in this. The outreach really belongs with the registry, which is not part of the judiciary and it's not part of the prosecutor's office. And of course it's not easy for court directors to get their heads around outreach. The registry is normally an administration, a bureaucracy, but that's where the onus must lie. And it's obviously not for the judges to start explaining what the organisation's about without forfeiting their independence and the perception of justice. Can I come back to one point that I think is very important, particularly having regard to the fact that we're sitting in Pretoria, and that is the question of the TRC and amnesties. If I may just make one brief comment, it's very important. Phil suggested that if there was a TRC in South Africa today, it would be inconsistent with the policy of the International Criminal Court. I would hope not, and I think that's one of the important features of the recent very controversial decision by a pre-trial chamber saying that the prosecutor could not investigate crimes committed in Afghanistan, which includes alleged crimes committed by the Central Intelligence Agency and the threats from Secretary of State Pompeo to have judges arrested, ICC judges if they come to the United States and so forth. But the pre-trial chamber did pay attention for the first time to the interest of justice, which is fundamental to the Rome Statute. The court can refuse to investigate situations if they're not in the interest of justice. And that's what the pre-trial chamber did in that case. But I believe, and it's something I used to debate at length with students and set as exam questions, I believe that a sensible prosecutor faced with a TRC in South Africa with discrete amnesties for full confession would say it's not in the interest of justice for the International Criminal Court to interfere in a situation where South Africans have decided to go that route and decided in a decision of their parliament. That made our TRC unique. I don't know of any other Truth and Reconciliation Commission that was set up by a legislature. They were set up by government, by the executive, and often by a president. And it seems to me that there is room in the ICC for that sort of broad approach, if it's genuine. And there can be no question that the TRC was. I mean, for example, to take it further, the TRC investigated crimes committed by South Africans outside our borders, in Swaziland and Botswana. Our security forces went and committed murders and kidnapped people outside our borders. If I was the prosecutor, I would say the TRC, if it happened, I'm not sure it did, but if the TRC granted amnesties to people, to South Africans committing crimes outside our borders, I would say no way. We're going to investigate that because South Africans don't have the moral right to forgive people for committing crimes in the territory of other government. So it's a complex question, but I agree with Phil. All these issues should be taken into account and not simply glossed over.
I think that's a really important point because I think the view, especially in the chambers at the moment, is that anything other than criminal investigations and prosecutions in a domestic context do not fulfill the complementarity threshold. That the view seems to be at the moment that even heavily conditional amnesties that are passed by national parliaments do not pass muster in terms of the judges in The Hague. And that I think is hugely problematic because, and I spend a lot of time also in the sort of peace and mediation world, and the view there is if we do not put in place systems that involve investigation and prosecution, if we propose any other kind of response to mass atrocity, we're going to have the ICC come down on us like a ton of bricks. And the examples that are always brought back are the Ugandan case during the Juba peace talks, 2006 to 2008, in which the LRA leadership were eligible for a national amnesty that had also been passed by the Ugandan parliament. And more recently, the case of Colombia. Coming out of the Havana peace talks, we see a very nuanced, complex transitional justice mechanism, which is an attempt to deliver criminal justice, but also to try to fulfill the need for truth and reparations. That is a mechanism that was done ultimately in the shadow of the ICC. The Havana mediators knew that they had to come up with something that would keep the FARC at the negotiating table while also keeping the ICC off their back. And I think in many ways it was a really admirable compromise institution that came out of those negotiations. Almost as soon as the Havana talks were ended and that mechanism had been passed by the Colombian parliament, we saw two statements by the Office of the Prosecutor in The Hague saying we are very skeptical of this institution. We do not think that it inherently will pass the complementarity threshold. And I think that sends a very dangerous message. That says to negotiators, you don't have very much room to maneuver here. And again, I think we need to go back to having a much more serious conversation about, to use your word, Justice Goldstone, the genuineness of the proceedings, not necessarily the genuineness of the criminal proceedings. I think the debate has become too narrow. I think genuineness of the proceedings generally is much more important here.
By way of sort of concluding this discussion, because I think it's a discussion that can go on for hours, right? We've spoken a lot about what the ICC should do, must do to improve. My question then, and this is my final question to the two of you, is let's say we know what the ICC has not done well and needs to improve on and what work needs to be done there. My question to you is, what about the states? What should states do? Because the one thing that we do have to remember is the court is a creature of the states, isn't it? It's a court that relies on voluntary association, but it's also a court that works primarily within the jurisdictions of states. So what are states doing right? Wrong? Okay, maybe let's just go with right for now, Phil.
So I was very pleased by the noises coming out of the last Assembly of States parties, which was that finally the big financial backers of the court were saying we need to have a serious discussion about reform of this institution. It's not working on its own terms and it's not working for communities on the ground. So I think that was really important. It's long overdue, but it's important. And I think that shows just how concerned the ASP is about the developments within the ICC over the last year or two, particularly the Bemba and the Bagbo acquittals. And I think even more so now there'll be concerns off the back of the Afghanistan judgment by the pre-trial chamber. That said, I was also worried by the nature of some of the prescriptions that were coming out of the ASP. So for example, and I've had this discussion with some actors in the British government, the British government was essentially saying the answer here is to cut the budget to the ICC. It's a period of austerity. This court is bloated. We need to trim it back. I think that's the wrong response. If anything, this is an institution that needs desperate bolstering. It needs a different type of personnel. It needs some discussions about elements of the statute. All of this is going to be expensive. And I think that the tenor of state reactions at the moment is not particularly helpful. I think the danger is that we may then see an even more debased ICC that is even less equipped to deal with complicated cases on the ground than it is at the moment. So good that we're talking about reform, but we need to be talking about serious reform and not just cutting branches off this institution.
Judge.
Well, I agree completely with what Phil has just said. It seems to me what the Assembly of States Party should do would be to set up an efficient, fairly small, maybe 8 or 9 or 10 people to investigate what's gone wrong and how to put it right. I don't think this can be done at an Assembly of States Parties where you've got 123 nations represented and each one wanting to have the limelight and to make a statement. You really need a small, independent expert group to sit down and be given access to all of the organs of the ICC, to speak to them in complete confidence, and to make a report quickly within 6 months to the Assembly of States Parties with recommendations as to how to move forward.
Thank you, Judge Goldstone. Thank you, Phil. I think at the very least, we haven't ended the conversation, that's for sure. I think we're really just starting a conversation, a critical conversation around how do you rebuild, reform, reshape the way in which the International Criminal Court is seen, but ultimately because it is part of an international criminal justice system. And one of the things, and this is more a plea really to states more than anything else, is that the heavy lifting of international justice ought to be done by states themselves. The prosecutions, when we speak about the crimes that are committed across various jurisdictions, those are crimes that are being committed in those states. The responsibility, not just stemming from the Rome Statute on its own, but from various own domestic legal processes, is on those states to be able to effectively address those crimes. Between yourself, Phil, as well as Judge Goldstone, I think you've shaped or at least begun this discussion around what are itemizing them, because sometimes we talk about things in the air. Itemizing what the issues are that need to be addressed, and then beginning to talk about the ways in which those can be done. But I think more importantly, and I like your last point, Judge, because you actually spoke to a very particular intervention by particular people. So not just saying the Assembly of States Parties, all 123 member states, but saying a small group of individuals, whether or not they represent states or not, ideally people with the technical, legal, and political know-how of the workings of international criminal justice, ought to put together or begin the work of looking at what's happened, and maybe they've got a reference book to start with, but also to look at then how do you feed that into an actual reform process. And Phil, your point is important, that it shouldn't just be reform for the sake of reform, but also it shouldn't be reform that does away with what the International Criminal Court is intended to do. Because in the conversation, we've spoken about one institution within the international criminal justice system. So it is about how do you ensure a reform that benefits the international criminal justice system. So thank you to the two of you for starting the conversation. Don't leave your seats. Thank you to the people who are here at the ISS for the seminar. We will have a closed roundtable discussion with you once the online feed is done. But thank you also to our online audience for your patience and for tuning in. And obviously, we always welcome what thoughts you might have, so you can email them, and Phil, and only Phil, will respond to them. A huge thank you to the School for Oriental and African Studies for funding this event and for allowing Phil, for some reason, to leave London and make his way to the southernmost part of Africa to launch his book, because no better place to launch a book that focuses on distant justice than on the African continent, and I know that you're going to Ethiopia next. And a particular thanks also to the members of our Partnership Forum, the Hans Seidel Foundation, the European Union, the Kingdoms of Denmark, the Netherlands, Norway, and Sweden, as well as the governments of Australia, Canada, Finland, Ireland, and the United States of America, without whose funding our work would be impossible. Thank you. Thanks, Richard. Right. Gosh, Phil, like honestly. If